No mention. Why so silent? Thank you.
May I please, Your Lordship? Your Lordship, I beg to mention item number 9, Your Lordship. Let this matter be taken up to Puja, Your Lordship, as Mr. Asdep is having some personal difficulties, Your Lordship.
Oh, this is for your reply.
Yes, Your Lordship.
We have brought the record, Your Lordship, in this case, both the cases.
This is for placing of the record. Two
Is it?
matters, my lord.
No, but I think Mr. Sangrisu he also wanted to reply. In fact, I remember, if I recall correctly, the other day he said it'll take about 1 hour for him to reply.
Yes, my lord. 15 minutes, my lord. I have got the original records. I can place those original records.
But
my lord.
if he is asking for time, then purpose of record would not.
Both the matters, there are two matters, my lord. There are two connected matters, my lord.
Yes, two connected matters. But if
Yes.
if they are to be taken up, it would be convenient to be taken up.
Together, my lord.
Together.
Together.
Oh, Mr.
Yes,
Sangrisu is here.
My Lord.
You are asking for time, or who's asking for time?
But we are ready,
We are
madam.
asking for item number 9, Your Lordship.
Oh,
As
okay.
Mr. Asdep is having some
Oh,
personal
Mr.
difficulties,
Deb.
Your Lordship.
Okay, I thought it was.
We are ready, my Lord. We are ready to conclude the matter.
Yeah, but what about Mr. Deb now? He also has to say something.
Yes, Your Lordship.
And hearing in piecemeal again becomes a
That
problem.
is the problem. That is the problem. If they are not ready, they should inform the AG or me. It's a big fight.
Both we are ready. We are ready with the
Right.
matter. We have
Yes,
When any time. My friend is seeking for after puja, my Lord. What to do? Everything will be forgotten again. It's a problem. Anyway, Lordship. Anyway.
Mr. Kumar is only thinking of enjoying his puja holidays. On Katika number 9, as submitted by the parties, lists this matter after puja vacation. Number 10, on prayer made by the counsel for the petitioner. 9 is Mr. Dev. You are asking for 9, and 10 is yours.
9.
No, 8 and 9.
8 and 9.
Your
Oh,
Lordship.
8 and 9.
Connected, yes, Your Lordship.
Yes,
Tukai,
ma'am.
8 katukan long katukan you, and 9 katong 9 on prayer made by the learned counsel for the petitioner seeking accommodation on grounds of personal difficulty. That is adjourned. Mr. Kumar, I will
Yes,
not
Lord.
I will not comment on the record being produced. You
Yes, my lord.
take it back with you and bring it on the next date. Okay. So thank you.
But your lordship's order is there to produce the record, my lord.
Oh, is there?
In terms of yes, your lordship.
Mr. A. Kumar Leonard AG has submitted that the records pertaining to the matter is produced before the court today. However, since no effective hearing could be done today, the records are hereby returned to be produced before this court on the next date fix.
No, blades, okay.
Yes.
Please, Your Lordship. Your Lordship, I beg to mention item 6. On behalf of the appellant, Your Lordship.
It is also only for filing of written argument.
My lord, I will be concluding only.
Oh, you?
Yes, my lord.
Last
Only
time you
thing,
were-
two or three documents I will be relying upon, and I have my written argument also ready. But before I submit my written argument, I would like to orally submit two or three points only.
I think oral submissions only.
No, oral submission is not over from my side. Only from the appellant side is over.
Oh. On pre-made by the parties, this is matter after 2 weeks. 2 weeks means what? Or you let us calculate again. I may be wrong also. Today is 17. Oh, yeah, I think 2 weeks.
Please, Lordship. Lordship, I'd like to make mention for item 11, Your Lordship. Lordship, in this matter, we have filed a affidavit bring on record the minutes of the meeting. Lordship is in the process of filing.
Oh, that. Where's Mr. Hajarka? Is it Mr. Hajarka? Not here.
We have served the copies, Lordship.
Okay, we'll take up the matter.
In the
You can make a submission when the matter is called up.
Yes.
Supplementary cost list item number 1.
that there was a scuffle between the complainant and the accused persons, the two accused persons before your lordships, my lords. And as a result of which the complainant has sustained injuries. I'm sorry, my lords, the complainant's brother has sustained injuries. Now, my lords, a case under section 326 has been registered. Now, the injury referred to in the FIR, my lords, is actually of displacement of the knee. Now, that in my humble submission, your lordships are aware, that doesn't come within the purview of 326 in the first place. And it is the admitted position, my lords, that the
Under 326, do they give a list of what
my
will
lords,
come?
what would constitute any permanent impairment or cut, my lords, would come as
Serious injuries? of
serious
course.
injury. Displacement of the knee, my lords, he says that he was sitting on a motorcycle, he fell down from the motorcycle and he sustained injuries. That is the limited case before your lordships, my lords. I would at this stage request your lordships may kindly call for the CD, but the statement would have to be examined. If your lordships please, my lords, I can take your lordships to the FIR.
The medical report.
Medical report would
DIO
have
submitted the medical report, lordship, in the lower court.
You have it with you?
I don't have it with me now.
So you produce it?
Yes, I'll produce it.
When?
1 week, lordship.
Today is the 17th. 31st.
Do it by 31st.
31st, lordship.
Lords, I would only pray your lordships grant me some interim protection till the 31st, my lords.
Lordship, because the item 2 and 3 are connected matters and they are the name accused in the FIR, lordship. And the report also reveals that they sustained grievous injuries.
No, the injury is mentioned in the FIR, my lords. I can take your lordships, page 13 if your lordships can listen.
That's beside the point.
And they are not cooperating with
mentioned
the-
in the FIR,
I'm
but
sorry, my lords.
it may be mentioned in the FIR.
Lordships.
But what is more, material is what appears in the,
Investigation of
medical
which is
report.
why I'm humbly submitting, my lords. Your lordships are hearing us on 31st. If you're after hearing us on 31st, your lordships feel, my lords, that it is otherwise, that liberty will be withdrawn.
Lordship. And they are not cooperating also.
So we'll cooperate, my lords.
reveals in the
Whenever
order.
your lordships say, my lords, we'll
Let
go
the
and
interim
appear.
be considered on the next day, lordship. When we
If by
produce
then, my
the
lords,
case diary.
there's no reason to keep the matter pending before your lordships. On 31st, your lordships will see the case diary and decide the matter, my lords.
Lordship, I'll take your lordship to this lower court order, the rejection order, lordship. Here, lordship, this
Page?
order, rejection order.
Where's the page? Page number?
That says, my lords, the lesser said about that order, the better.
They are not cooperating also. Lordship.
Your lordships may kindly look at the
paragraph three.
penultimate paragraph, my lords, at page 14. How can I be not cooperating? Even though the petitioners have appeared before the IO, there's reason to believe that they are not fully cooperated with the investigation. What more cooperation am I supposed to do, my lords?
Paragraph 3 also, lordship. They have not revealed their details, lordship, of the incidents.
We will call for the CD.
We'll call for case diary, lordship. Yes.
Heard Mr. Nepal, senior counsel appearing for the petitioner, who has submitted that this is an application under section 438 seeking grant of anticipatory bail. On behalf of the petitioner, who is apprehensive of likely arrest in connection with, what's the case number?
Haldiganj, yes.
Haldiganj PS case number, my lords, 7 bracketed 9 of 2023.
Where is it?
Page 5, your lordships will find it, my lords.
Haldiganj PS case number 7/9 of 2023 under section 326/34 IPC. Leonard Senior Counsel has, however, submitted that at this stage it would be proper for this court to call for the case diary. However, in the meantime, it is prayed that interim protection may be given to the petitioner. Given to the petitioner. Mr. H. Kharmi, learned additional PP, appearing for the state respondent, appearing for the respondents,
No, Chief, for
all the
respondent.
respondents,
Yes.
appearing for all the respondents, I have submitted that prima facie a case of assault has been made out, which is serious in nature. This being the case, the petitioner are required to be questioned by the IO, for which this application may not be considered at this stage. However, the prayer for production of this case diary is not posted by the learned additional PP. At this stage, this court is also inclined to look into the progress of investigation made by the IO and has considered it necessary for the case diary to be produced. Accordingly, the prosecution is to produce the case diary, copy of the case diary with the latest investigation report on the next date fixed. In the meantime, the petitioner for grant of interim protection is hereby allowed. In the event of the petitioner is allowed to go on interim bail on the condition that he shall not abscond or tamper with the witnesses and evidence, and that he shall appear before the IO as and when required. As prayed for, this is matter on 31st.
Highly obliged.
Obliged, Lordship.
Item number 3 is same. They're connected.
Same PS.
Highly obliged.
Obliged.
Daily costless item number 1.
My lord, this matter I was in fact preparing that part-heard matter of item number 8 and 9. Therefore, unable to prepare this matter, subject to lordship convenience. If the matter come up, my lord, on Friday.
No, not on Friday. I think it has to go after Puja. Friday,
In this case, my lord, the disputed land, the acquired land is situated both in East and West Khasi, East Khasi Hills and West Khasi Hills. But they have clubbed it along together in this writ petition. So I would suggest that, because I am for the district council, my lord, what has happened? The government, the state government, has not taken our consent as required under the law. Whereas in the case of the Jaintia Hills District Council, they have given permission. So they're quite distinct, different.
so there are a number of petitioners here.
Yes.
A number of
petitioners are there. Most of them are from Jaintia Hills,
Jaintia Hills.
and few of them are from East Khasi Hills.
You should have, segregate the matter with those. In fact, I think perhaps even the registry was not, made aware of this factual, aspect. In as much that cases pertaining to East Khasi Hills are registered separately, and those of other districts are also, similarly registered. So, as Mr.
In fact,
Dingo
I'm
has said,
supporting their case
Yes,
when it comes to
And
East Khasi Hills.
the council supporting the case of the petitioner.
Because the government never came to us for.
The land acquisition mandated that the
so if he's supporting your case, then
Yes.
his objection has more credence.
No, my objection is only in respect to segregation.
Yes, I think
Because Jaintia Hills have given the permission, then withdrew, then given it again.
it is a matter of land acquisition.
land acquisition made, the border fencing area, huge area has been lost. Citizen is going to lose the huge kilometers of land. without dispensing. This is the grievance, my lord.
Your Lordship, I appear
Just
for
after
respondent
Puja.
number 12.
Yes, Mr. Paske, we are just figuring out what is to be done. If that is the case, Mr. Sangreso, what do we do? Then this petition becomes defective.
My lord,
To that extent.
my lord, I have seen, my lord, the option was right. I could have filed separately for East Khasi and Jende Hills, but we filed collectively, my lord. There was no, even the High Court rules and other act did not prohibit this nature of filing. But now, since the matter reached to admission hearing, final stage, my lord, if we are allowed to amend it or segregate it, that will take some time. So, if Lordship hear it together, the issue is the same in one. Issue is the same in one.
I don't know. Maybe there could be some technical.
But there is no technical hitch or hindrance regarding final adjudication of this matter. Admittedly, the senior special counsel is correct. He is supporting the case of the petitioner.
But who is appearing for Jagdeo?
Jende Hills, my
And for
the
collector?
Union of India is the main party.
From the very first day, noticing that they had clubbed both districts, that was a plea even I had taken. That is highly unconventional.
Yeah, and this matter has travelled from 2021.
And since
Now we
it
are in
has reached to
2023.
final hearing, may I just pray after vacation, my lord, matter will be heard, my lord. Segregation will take some more time again. Withdrawing the petition and file a fresh one, similar exercise, that will delay them.
I leave it to the parties to examine, all the parties, examine this aspect of the matter, go through the rules, and at the end of the day, we have to abide by what is there in the rules and regulation. Otherwise, it may when an order is passed, it may come under objection by any aggrieved party, only on that ground.
On this issue.
But we will, my lord,
So then the
during
whole,
hearing,
again, it seems then the whole exercise becomes futile.
my lord, during the hearing, I will address this issue, my lord.
You try
I
to
will address this issue during the hearing.
on payment by petitioner, this is matter after 2 weeks.
I
Duly applies, Your Lordship.
Item number 2.
Your Lordship, you filed the affidavit of service, Your Lordship, regarding respondents 7, 8, and 9.
Anybody appearing for
For still respondents, I'm appearing.
7, 8, 9? Yes,
Although I do not have any instructions for him to appear.
you had appeared earlier.
My lord, I was for the petitioner. In the earlier read petition, my lord.
Yes, you are for this Sonia Sultana.
Yes, my lord. My lord, just for sake of justice, because so far I have not been instructed. But my lord, they have not yet received anything. I don't know on what basis affidavit of service is filed.
You see, that is a big question mark.
My lord.
The fact that this court would bona fide believe that since a certificate was issued, or rather, confirmation has been,
My lord.
posted in the website of the portal of the post office, indicating that the item has been delivered.
Yes,
So we take it that is service.
my lord. But it's not yet served, my lord.
Of course, there. I think if I recall, I have forgotten there's a Supreme Court judgment on this. In fact, especially with regard to Section 27 of the General Clauses Act, where this issue, receipt of notice and so on and so forth is dealt with. I don't know. There, I think it is said that once the notice has been issued and confirmed, delivered, it is assumed, or rather presumed, that the noticee has received, and it is incumbent upon them to appear. If I recall that matter correctly, I forgot the citation. But anyway, be that as it may, it would still be proper for the noticee to have received,
Yes, Your Lordship.
acknowledged receipt.
Yes, Your Lordship. As
Lord,
per
They are the main respondent. Lord.
my lord, the latest status, my lord, I tried to inquire just for a they have not received anything.
What you can do, Mr. Prasad, if you can, be kind enough to help, confirm with them. Just inform them that this matter is here. Pending, it's up to them whatever they do. And I'll accept the affidavit of notice, affidavit of service filed by the petitioner, and will not pass any order as far as their presence is concerned. We'll leave it that on the next date they have to appear. So that will give him some time.
okay.
But only provided another copy is served. Now, if a situation is such that here it is filed, but they have never received, then it will be again grave injustice.
No, that is why they may not have received. But like I said, since you have intervened, as a friend of the court for that matter, inform them that you are in the know that this matter is pending, whether you have received notice or not. You inquire or get instruction from them. So we'll leave it at that, and on the next date fix, if they don't come, then we'll see. They may come, they may not. Because again, proceeding ex parte would be
which address they have served the notice on. So I would, of course, I do not have the brief.
address given. The address given here, whether it's their residential address or school address or
The address we got from the.
it is a school address. No, because it is addressed to the principal. 7th is the respondent, I think the petitioner in the earlier case, and 9 is the managing committee. So 8 and 9 goes to the school.
Yes, Your
Must have
Lordship.
been received, except for 7 we don't know. But 7 is still a teacher there in the school.
My lord, she was the one who had challenged the appointment of the review petitioner.
Okay. No.
So that was set aside by this honorable court.
And was she appointed in her place or?
No, this honorable court had taken a decision, my lord, after a hearing, at length hearing, that the post should be re-advertised and thereafter appointment process should proceed with that. That was the case.
Where's the scope for review? Ms. Land Counsel appearing for the petitioner has submitted that the notice issued upon the respondents number 7, 8 and 9 respectively has been duly effected, for which an affidavit of service has been filed in this regard. At this point of time, Mr. K.P. Bhattacharjee, Land Counsel, who not involved in this matter, has, through his personal knowledge, informed the court that he has reliably learned that the said respondents have not received notice. Such assertion could not be confirmed or could not be confirmed by this court. Be that as it may, the Land Council is requested to kindly inform the said respondent of the pendency of this matter. It is, however, open. Forget. This being the case, the matter is posted to the next date to allow the said respondent to appear for the court. I think please do that.
My lord, if a little longer date is given, maybe by that time they might be receiving.
3 weeks.
Much,
This is matter 3 weeks.
much obliged, Lordship.
Item number 3.
May it please your lordship. Lordship, kindly come to Annex 4, your lordship. That is the last page of that compilation, your lordship.
Yes.
Annex 4. Lordship, here only the lordship, kindly see to the left. Only there is a typing mistake of the date, your lordship. It's dated 19 October, your lordship. That means day after tomorrow, your lordship. There is a mistake, your lordship. There is mistake, but the fact remain, your lordship. Leaving this aside, your lordship, if lordship kindly peruse the medical status report of the accused, your lordship, it appears, your lordship, that the accused, your lordship, she is stable, your lordship, and her health condition also is being monitored, your lordship, by the authorities.
See, miss, you are questioning the competency of the of the Negrims. Negrims is if not, I think it should be considered a super specialty institution, medical institution. It has got all the latest facilities.
That is there, your lordship.
You see, I think it would. I don't think Negrims in any way cannot attend to your to whatever requirements you have. This court would assume that if you wanted your surgery to be done at a particular hospital, it's only a pretext to be out on bail.
May please, lordship.
But if you so insist, well, I can grant you interim bail, but
Yes,
only for a
lordship.
period of
Only
for that particular period.
particular treatment, yes, lordship. Only just because she also having some other diabetes and all this. So during the time of when taking treatment, she'll be requiring the family members and all some. For that reason,
for that you have to give the details as to when you are required to be when you are required to be treated or operated. And how long
lordship,
it will take you?
as your lordship has suggested, so even only interim also for the purpose of taking the treatment, then she will take the necessary treatment and she will come back, your lordship. So even interim also, just for the purpose of taking the treatment, your lordship.
May I submit, your lordship? Lordship, on merits, your lordship, this honorable court was pleased to reject the bail, your lordship. Lordship, the medical status of the accused, your lordship, as per Annex 4, your lordship, lordship reveals that it's only for removing the implant, your lordship. Where is the treatment, your lordship? That can be done even in Negrim Hospital, your lordship. Negrim, as your lordship had rightly said, it is a specialized institution, your lordship. They have all the facilities, your lordship.
Mr. Shulai, you see, we have to be, we have to also take into account, personal preference of anybody for that matter. Even you or me for that matter. We may not prefer Negrim. We may prefer civil hospital. We may prefer
lordship,
Woodland or
maybe a ploy, your lordship.
Could be
maybe a ploy, your lordship.
It could be a ploy.
It's maybe a ploy, your lordship. Maybe a ploy, your lordship.
Apparently, it is a ploy.
It's a ploy, your lordship.
But this court cannot also.
Lordship, if the medical situation is so life-threatening, your lordship, certainly I would not have objected, your lordship, to the interim bail, your lordship. But going by this report and also the medical report of the attached in the bail application from Negrim, your lordship, in my humble and respectful submission, your lordship, I don't see anything as such, your lordship, that the life of the accused is in danger, your lordship. It's only removing that something, Your Lordship, from the left hand. Yes. Maybe update, Your Lordship. Even if that remains also, yeah, I don't think it does. It does not affect the
mobility
patient
of
also, Your Lordship.
the hand.
So my humble respect submission, Your Lordship, the question of interim bail, Your Lordship, or the question of bail on medical ground, Your Lordship, is liable to be rejected, Your Lordship.
See, if it is a
It's a ploy, Your Lordship.
complicated process, maybe, but
Yes, Lordship, because
apparently it's not a
the
complicated.
other day, even me, I personally went and visited the inmate, the accused person in the jail, and then I have seen also that her health condition has also deteriorated. And at this stage, Your Honor, I am humbly praying before this court so that she may be released at least for some time also, so that she can take the proper treatment. And moreover, though my learned senior has submitted that it is just a removal and all, but like it's not a kind of a small kind of stitches or some removal, but it's a procedure which is to be followed. I'm not saying that this is not competent or not competent, but during this process, when the process is done, she requires a proper care, and then emergency may arise, a situation may arise where anything can happen during that operation. And she's a patient of not only with regard to that, she's having some other diabetes patients and then some other pressure problem, and also during that kind of that time of situation. So for that reason, Your Lord, to give an effective, and she will come back, Your Lordship.
That is your observation. That would be your observation, but this court will also have to go by the opinion of or the report
Yes,
filed by the medical officer. You have got a copy of this?
No, I am not given the copy,
Give
Your
a
Lordship. I humbly pray, Your Lordship, may kindly, only interim also, Your Lordship, may please to kindly, Lord, then after the treatment she will come back and she'll abide by all the terms and conditions as Your Lordship may impose. Lordship,
I don't think. I think she has to go to Negrims. Negrims is competent enough. The implant is in the hand.
yes, Your Lordship.
Left hand, Your Lordship. Left hand.
What is the stage of the case?
In one case, both are in the stage of evidence. In one case, none of the witness has been examined, and in one.
How many witnesses are there?
Our Lordship at that.
9 witnesses.
They have not enclosed the short sheet also, Your Lordship. They have not enclosed the short sheet, Your Lordship. The complete short sheet has not been enclosed, Your Lordship.
9 witnesses.
Let me assess.
In one case, 12 witnesses, and in one case, 9 witnesses, Your Lordship.
Common, mostly common witness.
Yes.
Common.
Mostly common witness, Your Lordship. Mostly common.
No.
You have not enclosed the complete short sheet.
What, Miss? Yes. Sisa Learned Counsel for the petitioner, who has submitted that this is an application for grant of bail under section 439 on behalf of the accused person who is represented by the petitioner here. accused person I nak tengok Miss Srimati Kim Nicole Kongshai, who is represented by the petitioner herein. The facts of the case is that the accused person has been implicated in connection with Cleariat PS case number 65 of 2022 under section 21 under bracket C oblique 29 NDPS Act, which case after completion of investigation, charge sheet was accordingly filed by the IO, and a regular case being, what's the case number of the
criminal NDPS case number 11 of 2022.
regular case being criminal NDPS case number 11 of 2022 is now proceeding before the court of the special judge NDPS at Juwai or Cleariat?
Cleariat, Your Lordship.
Cleariat, East Genty Hills. The stage of the case is for recording of evidence. However, the learned counsel for the petitioner has submitted that the limited prayer made in this petition is for grant of bail to the said accused person to allow her to proceed for medical treatment at the medical institute of her choice, considering the fact that apart from other ailments suffered by her, she is also fitted with a metal implant in her
Lordship.
left arm.
Lordship.
Left arm or
Left arm, yes, Lordship.
left arm, and for which she was, or rather is under treatment in the, where is that hospital, Silchar?
Valley Hospital.
Valley
Silchar.
Hospital,
Silchar, yes.
Silchar.
Where?
It is therefore prayed that this court will be pleased to allow the accused person to go on bail to enable her to proceed to the said Valley Hospital, Silchar, Assam for treatment. Or in case the regular bail is not granted, an interim bail to allow this said accused to proceed for such medical treatment may be allowed by this court. Any terms and conditions to be imposed by the court will be abided by the accused person. Submit the learned counsel. Mr. Additional Learned EAG, appearing for the state respondent, has strongly objected to the prayer made in this petition and has submitted that the offence alleged to have been committed by the said accused person are very serious in nature, involving possession and use of alleged contraband substances, which in today's contemporary society has wreaked havoc on victims who have been lured into to consume such contraband substances, and as such, this being a crime against particular individuals and society at large. At this point of time, no leniency may be given to the accused. Secondly, the learned AG has submitted that the medical report and opinion of competent medical practitioners who are expert in the subject, particularly from NIGRIMS, full form, have given their opinion, their medical opinion, after examining the accused person and the latest medical status report filed by the Senior Medical and Health Officer, District Prison and Correctional Home, Joy, would show that the accused person is indeed suffering from diabetic mellitus and also had a metallic implant on her left hand. However, she was referred to Joy Civil Hospital on several occasions for medical checkup. She was also, the accused was also referred to NIGRIMS for treatment of the artificial implant on the left hand. And it is the advice of the attending orthopedic surgeon of NIGRIMS for the accused to undergo a surgical procedure for the removal of such implant. However, till date, the accused person has not given her consent to such advice, to such medical advice, but has insisted that the operation be performed at the said Valley Hospital, Silchar, Assam. Though this court is not in a position to fully comprehend the medical procedure involved as far as the said accused person is concerned, and can also and there are also no sufficient evidence to test the competency of treatment at the said Valley Hospital, Silchar, or at NIGRIMS. However, from the report given, the opinion given by a competent medical officer, it would show that the facilities at NIGRIMS and the medical attendants thereof would be sufficient for such an operation to be carried out. Given the situation, this court would impress upon the accused person to reconsider the option given and to get her medical attendance and the necessary procedure done at the Negrims. At Negrims. To Negrims along. No. Accordingly, on the basis of the above observation made, this application for grant of bail is found to be devoid of merit. The same is here, hereby dismiss.
Lordship, next item also same order will follow.
You see,
Lordship is only because of the condition, because at the time of treatment, of course I not give this. Also, Supreme Court also for the purpose of treatment, the Supreme Court had allowed to interim bail was given for the purpose of treatment.
But
yes.
Here is question of option.
Yes, Your Lordship.
Here is a question of option. When there is a a better facility.
Yes, here also.
If not a better facility,
Yes.
but a facility where it can adequately attend to your requirement. I don't see there is any harm in there.
Because previously when she was treated also, she was treated in that same hospital where they have implanted, so she find it confident in that hospital where and this is the situation where she will take the treatment and come back. It's not that she will not come back again to face the trial. She'll come back to face the trial, Your Lordship. This judgment actually, in fact, because the same matter in the other one also. This judgment also for the purpose of taking treatment in where the petitioner wishes to take
You
the.
should have a.
Yes, I thought.
Should have pointed out.
Lordship may kindly consider only for the purpose of treatment also, for an interim also, Lordship.
This is the judgment. Let me see, what is that judgment?
Just 1 second.
And this will not help you.
Because in this case also they have pleaded before the court for the purpose of treatment for a requirement.
Here,
So
it is not
the
clear.
interim was granted.
Here it is not clear as to what kind of treatment, whether specialized treatment is required at this facility where the petitioner or the accused would want. It is only
Been
perhaps
in
on that.
custody when the treatment taken, it's a different situation. For that reason, interim at the time of treatment. That's
Nothing is said
that's my
here.
humble view.
Nothing is said here.
Family members also maybe require at the time of.
They can always come.
anything. No, that is there, Your Lordship. But like.
There is no bar for them to be present. If you want a specific direction
No,
to that
Lordship.
effect, I will.
No, Your Lordship, Lordship, much obliged. There's same accused in the next petition also. Yes.
Same order.
Same accused only, Your Lordship.
Anyway, the option is given. See, the court will not force the accused to go for treatment at Negrims. If finally she doesn't want it, then perhaps we can consider at that point of time.
Lordship. Much obliged, Lordship.
Obliged.
Item number 7.
No, we will keep it now.
Yes. Yes, Mr. Samu, what's this right over?
Please, Lordship. This is the petitioner who is coming with regards to the illegal termination or illegal release from service, Your Lordship. Now, what happened in this case, Your Lordship? The petitioner, first he was appointed as a teacher, assistant teacher. May I take it? Assistant teacher on 28 September 2015, Lordship.
Yes.
In the school of Hirapara, name of the school is Hirapara SSA UP School, District West Garo Hills, Lordship. He was appointed by the managing committee, Lordship. Managing committee of
On,
the
when is the date of appointment? 22?
on 28 September 2015.
28.
Lordship. Appointed as an assistant teacher and was appointed by the managing committee of the Hirapara SSA Sarva Shiksha UP School. Lordship. Thereafter, she has been continuing in the school since from 2015 to 2019, Lordship. Then what happened? Keep it now as it is. Then may I take it to Annexure 2, Lordship. Now, Lordship, what happened? There was a letter where the managing committee of the school, page 17, Annexure 2 of my petition.
Yes.
Now, the letter was issued by the managing committee of the school, where on 15 February 2019, releasing the petitioner from the school,
yes,
saying that, alleging that she has participated in the election, which was held on 19 Dodan Raba Hajong Autonomous District Council on 21st January 2019.
That means she has contested in the election.
She said that she has contested the election during the holidays. That was
yeah, of course she has contested them.
Yes, in the year 2019, Lordship. Now, to that effect, they have released saying that this is the letter where it says that you have been released from service because he has contested in the election without taking permission from the school.
Where's the reference to any rule?
Any rule, Lordship? This is the letter where issued by the managing committee, Lordship.
Anyway, the respondent will have to answer that.
Yes. Let me just complete my submission. Yes. Thereafter, my lord, after she was released from service, the managing committee have referred the matter to the block mission coordinator, Your Lordship. They have sent a letter where it says that Annexure 3, Your Lordship, where it says that please enclose here with the petition on February 4th. Lordship, page Annexure 3, Lordship. Annexure 3, page 19. Annexure 3, page 19. This is the letter issued by the Additional Director, School Education and Literacy, District Mission and Coordinator, Your Lordship. In the letter, it says that please enclose here with the letter dated so and so, received from the President and Headmaster of Hirapara SSA UP School, complaining against the conduct of Srimati Florita D. Moman is the petitioner, assistant teacher of CRC coordinator Hirapara, which is says explanatory. You are therefore requested to require into the matter and submit a detailed report.
Require or inquire?
Inquire into the matter and submit a detailed report to the office of the undersigned within a week, Your Lordship. This is the direction given to the block coordination director to inquire into the matter. Now, my lord, I'll take you to the page 22, annexure 5. This is a submission from the administrative and the account official, Lordship. May I take page 22 of my report?
Page 22.
Lordship, annexure 5.
Yes.
Now, the inquiry was conducted. There is an order on 5/11/2019 where it says, Your Lordship, may I just read. On thorough pursuit of the report, number so and so, dated 08/08/2019, submitted by the block mission coordinator, Trikila BRC, it is observed that no proper permission or approval was sought for contesting the MDC election in Assam by Florida D. Moment, which is against the rule of the department. Thus, in view of the above, and as desired by the committee for taking necessary action from this end, undersigned for preventing such practice in future by employee, do hereby release Srimati Florita D. Moment from the post of cluster coordinator of Hirapara CRC, while allowing her to continue the service as assistant teacher of Hirapara UP school, with strict warning to be more responsible henceforth. Further, headmaster of Hirapara is hereby directed to take over charge of the office of the cluster coordinator Hirapara CRC with immediate effect. Now, my lord, what happened? As a punishment, Your Lordship, after the submission of the report, petitioner was released. Actually, it means that she was holding two posts, assistant teacher as well as the cluster coordinator. Now, for his misconduct, which he has committed, like saying that he has for alleged participating in the election, Lordship, yes, he has been punished. She has been punished with releasing from the post of cluster coordinator, from the cluster coordinator. However, the order is clearly stated that while releasing from the post of cluster coordinator, at the same time she was released, she was allowed to continue as an assistant teacher of Hirapara, Lordship. That means she has been punished, and then he was removed from the service of from the post of cluster coordinator, still allowed to continue as a assistant teacher in the Hirapara. But now, my lord, even after passing of this order, Your Lordship, the managing committee of the school have not allowed the petitioner to continue in the school, and then she was, as per the order, she has gone to the school, but her attendance was not recorded. She was not allowed to continue in this in service, Your Lordship. That is the whole case. Now I will come to the affidavit filed by the my learned friend, Your Lordship. Affidavit filed by the state respondent, Your Lordship. Before I come to the affidavit filed by the respondent, Your Lordship, my submission, Your Lordship, there is a procedure for termination if there is any allegation against the petitioner or anybody when person is removed from service or anything. There should be a proper procedure like issuing show cause notice, and then also after going to the show cause notice, if that is not satisfied by the authority, they can suspend or terminate as per the rule. These things were not done, Your Lordship. May I take you to the annexure 1 of the affidavit filed by my learned friend, the affidavit in the opposition. He was quite. He was not, date is not mentioned here, but in the original record,
Where is that?
There is only one affidavit in opposition filed by my learned friend from the government, Your Lordship. May I just read your lordship the annexure 1 from the affidavit in opposition, page 10, your lordship.
Just a moment. This is the affidavit dated
Affidavit
7.
filed in the month of somewhere in the month of because they have not mentioned the month in the date in my record. July. It should be the July 2022.
Yes, this annexure.
Annexure 1, page 10, your lordship. This is a letter from Additional Director of School Education Literacy to the Block Mission Committee, Trikikila, BRC Westcar, his lordship. May I read, your lordship? Yes. The letter dated 25/6/2019. With reference to subjects at the above, I am to inform you that the report submitted white number so and so dated 25 April 2019 with regards to the inquiry into the complaint against CRC coordinator Hirapara by you. It is observed that you have not conducted the inquiry involving both the parties but has submitted only the reply submitted by the coordinator, making it difficult for the undersigned in understanding the matter in its entirety. You are therefore requested once again to inquire into the matter involving all the stakeholders and submit a detailed report to the office of the undersigned within a week's time so as to enable the undersigned to initiate the necessary action from this end. This is for your kind of, your lordship. Here they are admitting that there was no inquiry conducted, disciplinary procedure conducted by the managing committee. Now, may I take you to the annexure. Next page is page 11, annexure 2, your lordship, where they have stated, lordship. This is the long letter, but last part, your lordship. Yes. The inquiry report complaint Hirapara so and so. With reference subject stated, I have the honor to submit the inquiry report on against Srimati Florita, the assistant teacher, cum CRC coordinator Hirapara UP School by the SMC of Hirapara SP School regarding the contesting of 19 Dodan Rabah Hajong Autonomous Council as a independent candidate, which was held on 21st January 2019 without proper permission of SMC of the above mentioned school. That, madam, the inquiry was conducted on 25 at Hirapara SSA UP School by school itself by the undersigned along with the BRBP Sri BP Nazari and Sri BM Sangma and MS Miss Coordinator Sri Rajiv Barman. During the time of inquiry, all the SMC were present. That, madam, during the inquiry, the assistant teacher cum CRC coordinator Srimati Florita gave her statement that she has contested the election Jordan Rabah Hajong Autonomous Council as an independent candidate, which was held on 21st January 2019. She told that she informed the headmaster through her father as she was unable to come and meet the head teacher as well as SMC member. It was also stated by the headmaster of head teacher of the above mentioned school that her father took signature from the head teacher on the blank sheet of the paper, and the head teacher of Hirapara SSA UP School, Sri Sengnang Moman, gave his signature with seal on the blank sheet of the paper without knowledge of the other SMC member. When inquired about the same, Florita D. Moman, assistant teacher cum CRC coordinator of Hirapara SSA UP School, unable to produce, stating that it was misplaced somewhere at home. It was also informed that SMC of the above mentioned school held meeting on 14 February 2019, and each meeting SMC member had decided to release Srimati Florita D. Moman, assistant teacher cum CRC coordinator of Hirapara SSA UP School, from her duty with effect from 15 February 2019 for her misconduct in duty. On inquiry, lordship, this is very important where I am trying to state, your lordship, on inquiry about the procedure of releasing her from the post of assistant teacher, the undersigned had observed that SMC did not serve so-called notice or explanation call before issuing the release order to Srimati Florita the moment. The undersigned also inquired final decision of SFMC member and observed that there was a mixed response. However, most of the SFMC members decided not to take responsibility in their own hand, instead decided to hand over to district mission coordinator to make best decision in order to function the school smoothly. This is for your kind information in the selection. Your Lordship, what happened here? The school managing committee in the report itself, it's very clearly stated that there was no cause, there is no so cause, there was no so cause, and also there is no proper procedure followed by the SFC committee while releasing the petitioner from service. The Lordship, it is in the administrative fact, your Lordship. To this effect, there is another order also in the earlier order where court also have asked them to produce some inquiry report, your Lordship. But however, till now they have not, your Lordship. The order dated 28/03/2020 is passed by December court, your Lordship, where it says, your Lordship, the order maybe in the order sheet also is there, maybe.
Order dated?
Order dated 28/03/2023.
Yes.
There is a direction from this honorable court, your Lordship, where it says that in course of hearing, it appeared that the record of the inquiry stated to have been conducted by block mission coordinator as reflected in this letter dated 08/08/2019, Annex 2 to the affidavit in opposition, where it says that the inquiry was conducted is necessary. Lanet GA for the state respondent to produce the same within 10 days. It is, no, your Lordship,
Yes,
why I am referring
just
this,
then,
Lordship.
you see, Mr. Prasad-ji, why is this record not produced?
My lord, record had produced. I was also produced. My lord, friend has not read the subsequent orders. He is only referring to those orders. Subsequently, it was produced. There is an observation of the court also.
Which
the original record is produced.
Record is produced, but inquiry was not produced. The inquiry, of course, there is subsequent order also. I will come to that also now.
Then we have to be clear on that.
Lordship.
See, if records are required to be produced for this court to produce, then before we proceed with the proceeding, with the hearing, then that has to be done.
My lord, it was produced. The court has gone through also, my lord.
But then, see, court means not this incumbent.
My lord, that is there. But
I have not gone through that.
It is reflected in the order. But nevertheless, my lord. Now, what had happened is that, my lord, this is the record. It is a two-page thing. But before my friend proceed further, my lord, my friend has clearly not mentioned the order of this honorable court dated, my lord, 6/9/2023. My lord, these matters were argued by him on that very day also. So if I draw my lord's attention, what this is before this court, my lord.
Yes.
My lord, what if I am allowed to read, my lord? Heard Mr. P.T. Sama, learned counsel for the petitioner. However, in course of hearing, the learned counsel has submitted that he may be allowed to file a list of books and authorities that he wishes to rely on. Trade is allowed, let the same be filed with advance copy to the respondents. Now that has not been done, my lord.
That we can now, so we can supply this there or under the list of book. We are ready to supply because.
Yes, true. But before that, I think it's see, this court was not aware of the earlier order for production of the record.
Yes.
My lord, the same arguments were placed before this honorable court. Please let me submit. The same arguments were placed before this honorable court on the same date, my lord. On this very date, my lord. Subsequently, my lord, we had also informed this honorable court that yes, record was produced. As per the directions of this honorable court, record was produced, my lord. Record was produced. Thereafter, it was returned to us.
No. Lordship, record was produced, but that it was found that there was that inquiry letter dated 08/08/2019. That was not there, your Lordship. That is not there.
Inquiry report, you mean?
Yes, inquiry report was not given. Report was only the they have.
My lord, report is there.
Only the same.
original report, my lord. What my friend is saying?
Yeah, it is the annexure only. What annexure 1 and annexure.
The report is the one which you have.
Yes. That is the same thing.
That annexure 2.
Yes, that is annexure 1 and annexure 2, Lordship. That is the same thing that they have produced. What court was asking in the order dated 28/03/2023. That is not meant for that. They are saying that our coordinator reflected in the letter dated 08/08/2019 annexure 1 to the PDP in opposition.
Just a moment, Mr. Sama.
Yes.
Record would be the file of the proceedings.
My lord, it is a very small file because, my lord, there was a bifurcation, my lord. However, this file that is forwarded to us, we have it in original, my lord. This is there with us.
And whatever the contents of the file is on record here.
My lord, on record here.
So then it's not necessary.
Yes, my submission is record they have produced, but it found that there was no inquiry as such. No inquiry.
Oh, that is your.
Yes.
That would be your submission.
Yes, my submission.
That is based on what you see. Whatever you have led this court to see the contents of the affidavit.
Lordship.
So there's no
that
requirement
the inquiry report.
So there's no requirement for this court to call for record.
My lord, it is already here with us.
Yes.
Well, then fine.
So
I'll note it down.
My only submission is only there was no SOCOS notice, no departmental proceeding, no actually prior to this one there was no termination, there was no cost notice, no document, nothing was supplied, and this in this affidavit in opposition they have clearly admitted that no proper inquiry was given and no final decision of SSMC member. Now SSMC member is only saying that it is duty of the state respondent state to decide on the matter or my termination. My submission is that since whatever may be the reason, so maybe that petitioner might have committed a mistake or this was by contesting, but my submission is that should be a proper procedure which they have not followed, and it is admitted in the affidavit in opposition saying that there was no SOCOS notice, no document and no supplied to furnish to the petitioner. There was no proper inquiry into the matter. There was no departmental proceeding. Now, with regards to which my learned friend, I will be submitting the release of paper which I prepared. This is the book, my lord. I will be giving to them also, your lordship. This one. That's because I Xerox, I cannot produce each and every book, but the book is here, lordship. I will give it. This is what my learned friend is asking. I Xerox for everybody. This is the book. I say, lordship.
Yes.
Now I will take to the the page 28, your lordship. There is a comment, your lordship. And this ring 30. May I read, lordship? There is a page 28.
Page 58.
Page 28 of that book, lordship. Page 28. It starts from the page 28. Actually, it is starting from page 27. Page 27, your lordship, is the page 27, chapter 4, the terms and conditions of service of the employee recognized so and so. I rely on the 4. This one is there.
You are referring to the Meghalaya School Education Act.
Lordship, this is this one, your lordship. Lordship.
This is section 9.
This is section 9, 4.
9.4.
Lordship, may I read, your lordship?
Yes.
Well, the managing committee of recognized private school intend to suspend any of its employee. Such intentions shall be communicated to the competent authority, and no such suspension shall be made except with the proper approval of the competent authority, provided that managing committee may suspend an employee with immediate effect and without the prior approval of the competent authority if it is satisfied that such immediate suspension is necessary by reason of gross misconduct within the meaning of code conduct prescribed under section 10 of the Act. Provided further that no such immediate suspension shall remain in force for more than the period of 30 days from the date of the suspension unless it has been communicated to the competent authority and approved it by it before the expiry of the said period. Lordship, this rule is clear that without the prior approval from the government, the managing committee, they cannot take any action. Here in this case, Your Lordship, they have released the petitioner from service, meaning that not allowing to continue in service. It's amount to termination or suspension without prior approval of the authority, Your Lordship. Your Lordship, another Lordship. This is the same thing where it's this is Lordship. I have just get it. Just take it this one. You give it to them. This one, like this one.
Where is this?
There is a page 11 yellow. This is actually the Meghalaya School Education Act 1981. It's the same thing. It is same thing, Lordship. Here also it says that any employee of recognized.
Because you are reading the same thing.
Yeah. Yes. Same thing. Yes.
Same thing.
Yes. Lordship is not required to be this one. Now, my lord, I'll just come to this one. This is
yes.
This one. Your Lordship, what happened, Lordship is very much aware, Your Lordship. In prior, this is the amendment, Lordship, which I got it from this one only. But in that, this is the Meghalaya State Education Policy in page.
There's
86.
No indication here. What?
Because I just got it, this one. I have prepared the book list. Meghalaya State Education Policy Laws.
You should say that.
Page 86. I think I have given all this.
Where is page 86?
Page 86.
There's no page here even.
Oh, I think. Oh, that is by mistake. My learned friend has by mistake he has given another one, Your Lordship. Here, Your Lordship, I'll come one by one, Your Lordship. Yes, I will try. Why I'm trying to this one. Here in the page 86, the 7.7
page.
Page 86. 86 point. There is a point is given 7. .3.
Yes.
There it says the government and government-aided colleges, university teachers will be barred from taking part in political activities and political association. Now this,
how's this?
Lordship, what I'm trying to say is now this has been already set aside by the division bench of the Honorable Court. Your Lordship.
This is confined only to colleges.
Yeah, Lordship. Now I'll come to the colleges. Now this not.
What is
page 94, Your Lordship.
Okay.
Of
94.
this.
What does it say?
Now this notification, Your Lordship. This notification of March. Yes, notification. It starts from page 90. Page 90. Start from page 90, where the Governor of Meghalaya pleased to amend the rule. I'm taking from page 90 of this one. Now in this Your Lordship, that may I read, Your Lordship? Yes. This is a notification issued on 23 March 2011. It says that the Governor of Meghalaya is pleased to amend the rule of conduct and discipline of the employee aided educational institution as follows. Namely, there is a original act, Your Lordship, that may I take you to the number the amendment rule 6 and amendment rule 2, Your Lordship. In the existing rule 6 of the word except in accordance with provision of rule 7 may be omitted. Then second, the provision of 6 rule shall be omitted. Now in the original act, Your Lordship, original act we have this one. Actually, it was this is the original act, Your Lordship. The amendment in the original, Lordship, I take you to the 6 and 7. Just read it, the 6 and 7.
You have not page mark here.
It is page. It will be at page. Yeah, they don't put a page number, but in the.
Lord, my friend should have prepared a list of books. Should have given advance copy to us. Lord, the current rule he is referring to, we do not.
We are supplying the copy to them also.
Mr. Prasad has pointed out that order, the order of this court.
It's a very clear order.
It is said in that order that you prepare a list of authorities and books with advance copy to the respondent. You have not done that, and now straightway you have come.
Yes, madam.
And they say that they are taken by surprise. They could not respond.
No, this current
and
rule, whatever is referring to, we have not been given a copy, madam.
We have given now only. It is there. Whatever I am replying, I am giving and supplying the copy.
Now in advance, what does it mean?
My lord.
But it's not. They can just read it.
Do it properly, sir. And this, you see, I will not accept this. No page mark, no indication, nothing is there.
Neither is it marked in our papers.
Do it properly.
Otherwise,
do it properly.
Lordship. Otherwise, my lord, why I'm trying to reply is
we'll take up the matter on the next date. But you have a case.
Lordship. Lordship,
I has not been followed.
My lord, let the petitioner argue, my lord. No, most importantly, my lord, he has not challenged his termination order. Neither the resolution of the termination nor the termination order. That is not under.
You have annexed the termination order.
See, Lordship.
No, he's not.
Lordship. The first instance, I have stated that none of those documents, even termination, nothing was given. It was that termination was given only in the affidavit.
My lord, even
if that is the case of the respondent, that they have supplied the document, now they have to prove me when.
How did you know that you have been released?
No, only the release order, not a termination.
My lord.
Release termination, what is? Okay.
No.
You said that release also.
Release order they have given me. I am not denying. I have enclosed also. There was another termination also that they have enclosed only at the time of the affidavit.
Then you have you filed a rejoinder?
My lord.
I have filed it, Lordship.
My lord, what he should have done, my lord, what the petitioner should have done, my lord, the moment the copy is supplied, my lord, included in the affidavit, he should have withdrawn this writ petition with a liberty to file a fresh writ petition challenging that order, my lord.
It is up to the petitioner to choose, because it is only just for the purpose of delaying the matter. Have it been the case that they have supplied all the documents, let them prove that when they have submitted the copy of the termination letter.
Who will supply, my lord?
They are saying that who will supply? It is the case of the. It is the rule is very clear.
Fine. We'll do one thing, Mr. Prasad. You do one thing. You prepare everything in order.
Lordship.
Give them a copy.
Yes, it may be reflected. I will submit all the copy right now. It may be reflected because they are saying supply. Otherwise, during the course of hearing, it is a practice. Whenever we are replying, we always.
No, my lord. This rule he is referring to, we have not been supplied to us.
No, now you return back. I will press supply the copy again, because I will supply again. Let them receive it. Whatever I have supplied, I will.
Yeah, they will receive it, of course.
Let them receive it in the copy. We'll put it in a proper way, and then I will supply it in advance. Let them receive in the copy.
That is what we've been saying all along.
My lord.
No, Your Lordship, usually what happened, even during hearing, people, whenever we reply, we used to give them, they can also see. It is not advance supply, means it is only what I am reading, they also are reading.
Since it is an order passed by this court.
Yes.
If you had, at the relevant point of time, if you had said that it's not necessary, the court would have recorded that.
My lord.
But now at this point of time, you see.
Okay, I will supply, Lordship. I will supply in advance. Later matter maybe now this week may not be possible, Your Lordship. Maybe it can get after puja only, because.
Mr. PT, someone direct counsel for the petitioner, has submitted that the list of books and authorities could not be copies of the list of books and authorities could not be handed over to the state respondent in advance. It is prayed that the same may be allowed to be supplied today.
During this week, Your Lordship,
within the
I prepared a compilation like
within
or
the next
whatever.
date fix for this case,
Lordship,
for which accommodation is sought for.
Lordship.
You could have said that in the.
I prepared like
wasted time.
yes.
I thought this matter could have been, finished today.
Otherwise, this is the book we have. What this is that difficulty? I don't know why. How this that having difficulties? Just they can go through that.
Whatever authorities you are, any citation, any give copy to them.
No, there was a direction of this on the book.
In fact, you should have given a advance copy to us, to the court also. I don't think we have received.
No.
Lordship, I prepared
a whatever
compilation.
The compilation or the the judgments you are relying on, that advance copy should be given.
Yes, Lord. Next time I'll prepare the spiral binding so that it will be easy to.
Yes.
Yes,
do that.
that is more easy. Giving them one by one. So.
Okay.
I'll prepare the spiral binding, distribute it to them also.
This matter after puja wish.
Lordship. Yes. Much blessed, Lordship.
Item number 10.
May it please Your Lordship. Kindly take up this matter on some other day, Lordship.
On pre-made by the Learned AG, not objected to by petitioner. Matter is adjourned decisive after 3 weeks.
Apply.
Item number 11.
Yes.
Please, Lordship, we will be filing this affidavit bring on record the minutes of the resolution, Your Lordship, which is being held on 31st 8 of 2023. The filing in the course of the day, Lord. We're waiting only for this client's signature, Your Lordship. She came all the way from Garo Hills. So we'll be filing in the course of the day, Your Lordship.
Here, my lord, only the resolution taking that he is, we are not accepting him. The question is coming, first of all, they are making objection that we are mutually settled, that also gone. Then they are telling that this appointment letter also forced, that also gone. Then they have produced the registered attendance, that one also rejected. Now they are coming for another resolution, whether all this thing is required in the review petition or not. That is the main question, my lord. And in this way, they are taking time, one after another plea they are making. So I pray, my lord.
Since this court has allowed allowed them to take action,
yes,
or rather for the matter to be
settled. Yes, my lord.
But let them file whatever resolution they have or minutes. You have not received copy.
We have supplied, Your Lordship.
I received just now.
You have received.
Yes.
So since you have received, then we can take up the matter.
Yes, you can continue. No problem.
Yes, no. We haven't, Lordship, we are waiting for this client signature, Your Lordship. So
it was an advance copy. Please, you have to file, bring on record.
Again, next date they may come, he is suffering and they are not filing.
After puja, Lordship, puja vacation.
Only they are taking time.
The petitioner is here.
No, Lordship, she's from Garo Hills, Lordship.
The way you said it, as if she's right here.
Lordship, she's on the way, Lordship, Filing the cause of the day.
First you say she's in Garu Hills, now you say she's on the way. What do? We'll wait here and till she comes. She or he?
She, Lordship.
Unnecessarily matters delayed. Review petitions do not take
Very limited scope.
And
scope, very limited.
More advantage for this and that.
Mr. Letter Counsel for the petitioner submitted that in deference to the direction made by this court, a resolution has been passed by the managing committee, which would be material for consideration at the time of hearing of this petition. It is, however, submitted that since the deponent is a resident of Garu Hills and could not come to Shillong in due time, it is prayed that this matter may be adjourned for the day and to allow the relevant affidavit to be filed in due course. On prayer made by the General Counsel, the court would allow the said affidavit to be filed. It is, however, made clear that if the same is not filed within the next date fixed, no more opportunity will be given for the same, and the matter will be heard finally. You can you fix a date, or what do you think?
After Puja, Lordship.
After Puja, after Puja it could be December, could be January.
After 31st, Lordship, of this month.
31st then. List this matter on 31st. So that will be final, no more.
Second call from supplementary cost list, item number 1.
Just bring it.
said anything about the
Yes, yes.
because that would be involved another lengthy hearing on that.
Hello.